My name is Alison Fines and I teach contract law in city colleges. For today's purposes, we're going to look at three things. First of all, we're going to take a look at an overview of the contract law exam. We'll then look at exam technique with particular focus on the examiner's reports, and then we'll move on and take an overview of the FE1 contract law course. So first things first, for the contract law exam, we're required to answer 5 questions of a possible 8. The exam paper is comprised of 4 problem questions and 4 essay questions. Overall, we've got 3 hours to answer the exam. With 5 questions, that works out at 36 minutes per question, so we would suggest that you would use 30 minutes to write your answer and approximately 6 minutes then to review and prepare for your answer. Looking in more detail at the types of questions then that are asked on the contract law paper. Problem questions. First thing I would say about problem questions is there's a mixing of topics when it comes to problem questions on this course. Therefore, in order to succeed in this exam, you really do need to have an overarching knowledge of the entire contract law course. Typically, we're looking at about 3 topics per problem question. There are, however, a number of common topics that come up in problem questions. Quite often, we have offer as an issue which arises in a problem question. We're asked to look at things such as whether or not an advert or an auction without reserved is an offer in the particular factual circumstances. While I do pinpoint that offer is very frequently asked as a problem question, I do note that in March this question actually came up as an essay question, but it is something that you should bear in mind. We frequently have questions in the problem section based on consideration and estoppel. We look at things such as the absence of consideration and whether past consideration is good consideration. Mistakes are also a very common problem question. We've got 3 different types of mistakes. We've got unilateral mistakes, common mistakes, and mutual mistakes. Very, very frequently, problem questions take the form of exclusion clause questions. This is where an individual attempts to exclude or limit their liability under a contract. Finally then, I would say you should be very much aware of the damages section of the course when it comes to a problem question. This can be quite a manageable question to answer, as it's an exception to the general mixing of topics approach taken to problem questions, in that it frequently comes up on its own, where you're asked to advise as to what heads of damages an individual might recover. Looking then at the essay questions on the course, we see that the essay questions cover quite a number of topics. However, I would say that there are particular topics which lend themselves exclusively to an essay question approach. This namely would be the EU consumer directives as a good example of that. So now that we know what is on the exam, it's very important to know what to avoid on the exam. So if we take a close look at the examiner reports from the last number of years, we see common things arising again and again that the examiner is indicating students are making errors on. So there are 6 do nots when it comes to the contract law exam. The first one, do not learn off notes and regurgitate them without answering the question. This is again and again flagged by the examiner as an issue in the contract law exam paper. Do not provide lots of detail on uncontroversial matters. Rather, you need to identify the issues in the problem question. Do not misunderstand the difference between the way in which the Sale of Goods Act applies to consumers and applies to commercial contracts. It's a common misconception that this legislation applies only to consumer contracts. While certain provisions do apply only to consumers, there are provisions of these legislative schemes that apply also to commercial contracts. Number 4, do not misunderstand the distinction between a void contract and a voidable contract. This is something which the examiner indicates again and again students are finding difficulty. Penultimately then, do not fail to apply the law to the facts of the case. And finally, do not fail to support the arguments that you make with case law. So finally then, for an overview of the course. While it might seem at this point that there's a lot of material to cover, overall this course can be split into 3 key questions, and this is a system which can help us manage the large amount of material we have to cover. Question 1, do we have a contract? Question 2, what constitutes that contract? And finally then, how do we get out of the contract? And I will look at these in more detail in the next lecture.